Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to tell you about cancellation of removal for non-permanent residents. I have to tell you that this is a very vast, very large topic because there are a lot of different details in it. But here I'm going to speak in general about what cancellation is, who and how may apply for it, and what to watch out for. So first of all, cancellation of removal is a relief from deportation or removal available in court only. It means that a person cannot file for it with USCIS. A person will have to be placed in removal or deportation proceedings to submit this request with the judge only. Only an immigration judge has jurisdiction to decide the cancellation of removal application. So how that usually happens? How does one end up in removal proceedings? If somebody, for example, filed for asylum with a much missed deadline, and I'm smiling here because many lawyers has been using this this technique for someone to end up in removal proceedings and later file for, instead of asylum, to file for cancellation of removal. The problem is that many clients did not know that the lawyer had this particular plan for them and were surprised when they ended up in removal proceedings. The other problem is that apparently USCIS itself recommended this route and later retracted it. So I never particularly liked this particular technique to leave somebody in, to end somebody up in removal proceedings this way. The better way to do it, the correct way to do it, if you would like to be placed in removal proceedings, if you're that courageous, is to ask ICE for discretion to place you in removal proceedings. But you have to understand that there is a chance you can be removed. All right, so people who qualify for cancellation of removal are people who have 10 years of continuous presence in the United States. This 10 years is the time, usually, that the person entered the United States from until the person is either placed in removal proceedings, and this happens when the person is served with notice to appear, or the person commits a certain crime. The commission of a certain crime would stop the 10-year presence. It means that sometimes a person will be in the United States for 20 years, 30 years, but he or she will not qualify for cancellation of removal because, let's say, long time ago, right when the person tried to enter the United States, he or she was ordered removed, so the clock stopped for that person, okay? Or the person committed a certain crime that stopped the clock. 10 years, interestingly, will not be interrupted if a person leaves the United States and comes back. It means that permanent bar, a problem for adjustment of status very often, may not be a problem in certain situations for the cancellation of removal. Interesting, right? However, the person may not be absent from the United States for more than 90 days or 180 days altogether. Also, if a person left the United States under the threat of deportation or removal, that would count as leaving permanently. Doesn't matter how many days the person actually stayed outside of the United States. The time will be interrupted. So that's the first requirement, 10 years. Second requirement, the person has to be a person of good moral character. Usually it means that the person did not commit certain crimes. The person should not be convicted of certain disqualifying crimes, and the list of those crimes is a long list. Pretty much everything will disqualify a person, or any conviction will disqualify a person from being able to file for cancellation of removal, but there are some exceptions. So a person would have to consult with an attorney if he or she has some little convictions. It's still possible. It will be a big negative factor, of course, but it's possible. And last and very important qualification point. A person has to have a relative who is a US citizen or lawful permanent resident who will suffer extreme hardship in case the applicant for cancellation of removal is removed outside of the United States. I think this point sometimes is missed by many. It means that the person has to have a spouse, a parent, or a child. For this particular purposes, the law allows to show hardship to a child who will suffer extreme hardship, well, the law says exceptional and unusual hardship, but they use the same standard as extreme hardship if the applicant for cancellation is removed outside of the United States. This is one of the hardest points to prove because it doesn't have a strict criteria and sort of subjective, and different judges will agree or disagree with different points. Usually to prove that, a person will have to demonstrate that the relative has some medical conditions, is reliant or relying on the applicant for financial support, emotional support, physical support, and so on. And of course, we have a discretion element to it too, meaning that the judge is going to look at everything in the aggregate and will decide whether or not an applicant deserves cancellation of removal in the United States. That's very important. That's where usually the good moral character and letters of support come in, because the judge has to feel good, so-called, about giving somebody cancellation of removal. Now, cancellation of removal is different from adjustment of status in various aspects of it. It's important to know that even though when one files for cancellation of removal, he or she has to pay a fee for it and will receive a receipt saying that adjustment of status fee was accepted and paid. But it's different from adjustment of status. The difference, for example, is in that, as I said, permanent bar may not be a problem for cancellation. The person will not have to submit medical exam with the cancellation of removal application. And there are some other aspects of this relief. So it can be good if you qualify for it. I wouldn't recommend anyone to jump into it themselves because, as I said, there is always a chance for a person to be removed. Now let's talk a little bit about stop time rule. Stop time rule is a rule that is referred to that stopping of the 10-year continuous presence requirement in the United States. When it's going to be triggered. It's going to be triggered if a person is served with notice to appear. And this is one point I would like to talk to you about. Recently, about a year and a half ago now, year and a half, yes, so I think so. The United States Supreme Court stated that a person who received a defective notice to appear that does not have time and date for the person to come into court but says TBD, cannot serve as a notice to appear that stops the time for 10-year cancellation of removal relief. Later courts, immigration courts, Board of Immigration Appeals stated that, yeah, it's true, but if a person later received a hearing notice saying when to come to court, then the service was perfected. The service was perfected and the person now was served with notice to appear. It means that if someone had an order of deportation from a long time ago, he or she may have a chance to show that he or she was not served properly with this notice to appear and now may qualify for cancellation of removal. But this will depend on what's in that person's file. a person would have to order his or her file from the United States Immigration Court system and see how exactly he or she was served. Was there a proper notice or not, as determined by the relevant court decisions? Okay. There are other aspects, many different aspects about cancellation of removal relief, like which crimes will disqualify the person, what date we're looking at when we say that the crime was committed. For example, for conspiracy, it's not a conviction. It's when, I believe it's when the conspiracy case will be regarded as started or began from the time conspiracy started, not from the time the person actually was convicted, for example. So sometimes the crimes that would disqualify a person, the appointed time, can be very relevant and can be very technical, okay? And judges and lawyers may disagree about that. That's why we have all these decisions in courts that render different opinions on a point. At times, the crime can be a very small crime that will actually not trigger the bar on cancellation of removal. And one last thing. For cancellation of removal, there are groups of people who cannot file for it, even if they wanted to. Though the people who arrived on a crew member visas and certain J1 visas holders, okay? They're statutorily disqualified from filing for cancellation of removal. I actually do have some videos about cancellation of removal already on my channel, and I will post links in the description. So if you would like to learn more about it, you may. And very last point, even if you win your cancellation of removal case nowadays, you will not become a permanent resident on the same date. There is quite lengthy backlog right now. You may have to wait for about 2 to 3 years to get your green card, actually. So it's something to keep in mind, okay? Why? It's because there is a limit on how many visas can be allocated, immigrant visas, green cards, can be allocated for this particular relief. And when they get exhausted, we have to wait for the next year. And the judges basically receive the information as to which visas are available, depending on the date when the case was submitted to court. Thank you for watching and stay tuned for more videos. Thank you.